and other railway competitive examinations. Procedure for imposing minor penalties under Discipline and Appeal Rules, 1968 of Indian Railway. 1. No order imposing on a railway servant any of the penalties specified in clauses 1, 2, 4 of Rule 6 shall be made except after a. Informing the railway servant in writing of the proposal to take action against him and of the imputations of misconduct or misbehaviour on which it is proposed to be taken, and giving him a reasonable opportunity of making such representation as he may wish to make against the proposal. b. Holding an inquiry in the manner laid down in Subrules 6, 2, 25 of Rule 9, as for major penalties, in every case in which the disciplinary authority is of opinion that such inquiry is necessary. c. Taking the representation, if any, submitted by the railway servant under Clause A, and the record of inquiry, if any, held under Clause B, into consideration. d. Recording a finding on each imputation of misconduct or misbehaviour, and e. Consulting the Commission where consultation is necessary. 2a. Holding of inquiry is on the discretion of disciplinary authority, Clause B of Sub-Rule 1, mentioned above. It shall be necessary, if in a case, it is proposed, after considering the representation, if any, made by the railway servant under Clause A of that sub-rule to withhold increments of pay, and such withholding of increments is likely to affect adversely the amount of pension or special contribution to Provident Fund payable to the railway servant, or to withhold increments of pay for a period exceeding 3 years, or withhold increments of pay with cumulative effect for any period, an inquiry shall be held in the manner specified for major penalties, Sub-Rule 6, 2, 25 of Rule 9, before making any order imposing on railway servant any such penalty. 2b. With reference to Rule 9, in Sub-Rule 13, 1, for Clause A, the railway servant may represent his case with the assistance of any other railway servant, including a railway servant on leave preparatory to retirement, working under the same railway administration, subject to whose jurisdiction and control he is working. He cannot engage a legal practitioner for the purpose, unless the presenting officer appointed by the disciplinary authority is a legal practitioner, or the disciplinary authority, having regard to the circumstances of the case, so permits. If the railway servant is employed in the office of the Railway Board, its attached office or subordinate office, he may present his case with the assistance of any other railway servant, including a railway servant on leave preparatory to retirement, employed in the office of the Railway Board attached office, subordinate office, as the case may be in which he is working. The retired railway servant concerned should not act as a defence helper in more than 7 cases at a time. The retired railway servant should satisfy the inquiring authority that he does not have more than 7 cases in hand, including the case in question. RBS No. E. D&A, 2002 RG 6-13 of 14th May 2003 Bahris 23/2003. A non-gazetted railway servant may take the assistance of official of a railway trade union, recognized by the railway administration under which the railway servant is employed, to present his case before an inquiring authority, but shall not engage a legal practitioner for the above purpose except in the circumstances brought out above. As official of a railway trade union shall not be allowed to appear on behalf of an alleged delinquent railway official in connection with a disciplinary case pending against that official, to present his case favorably before an inquiring authority unless he has worked as such in a recognized railway trade union for a period of at least 1 year continuously prior to his appearance before an inquiring authority for the above purpose, and subject to the condition that he takes no fee. R.BS No. E. D&A 96 RG 6/68 of 13th August 1997 Bahris 109/97. If the law assistant of railway administration does not appear or plead before any court of law administrative tribunal on behalf of the railway administration, but only assists the railway advocate at the time of hearing, there should be no objection to such law assistant acting as defense helper in disciplinary inquiries. RBS No. E. D&A 89 RG 6-132 of 10th January 1990, Bahris 498. 3. Orders made by the disciplinary authority shall be communicated to railway servant, who shall also be supplied with a copy of the report of the inquiry, if any, held by disciplinary authority, and a copy of its findings on each article of charge, or where the disciplinary authority is not the inquiring authority, a copy of the report of the inquiring authority and a statement of the findings of the disciplinary authority together with brief reasons for its disagreement, if any, with the findings to the inquiring authority, unless they have already been supplied to him. 4. Railway Board wide their letter No. E, D and A, 86 RG 6-12 of 17th February 1986, Bahri 2686, have advised that in cases of imposition of minor penalties, where no inquiry is held, the disciplinary authority, while passing orders, should communicate to the employee concerned the brief reasons for the final decision regarding the guilt of the employee. Following impact of penalties on promotion. 1. For penalty of censure, may be called for selection and may be promoted. 2. For penalty of stoppage of promotion, shall not be called for selection and shall not be promoted. 3. For penalty of recover of loss, shall be called for selection and shall be promoted. 4. For penalty of withholding passes toes, shall be called for selection and shall be promoted. 5. For penalty of withholding increments, shall be called for selection and shall be promoted during penalty. 6. For penalty of reduction to lower stage, shall be called for selection and shall be promoted during penalty. 7. For penalty of reduction to lower time scale, shall not be called for selection and shall not be promoted during penalty.